Can you expect a fair hearing before the government takes a decision that affects you in every case? This is how we usually begin, and today is no different. Rajasthan State Industrial Development and Investment Corporation versus Subhash Sindhi Cooperative Housing Society. The Rajasthan government notified on 18/7/79 under Section 4 of the Rajasthan Land Acquisition Act 1953 to take over the land, including the land in dispute, for the public purpose of industrial development. This land was taken in possession by the government in 1982 and given to RICO in 1983, who in turn gave the disputed land to Diamond and Gem Development Company in 1989. This disputed land was transferred by the owners of the land through an agreement of sale to the Respondent Society for the construction of residential premises on 21/7/81. Meanwhile, the state government issued circulars, including circular dated 1382, providing exemption of land from any acquisition proceedings. This exemption was granted for those lands that had constructions on them or was sold after the issuance of the notification, with the cut-off date as 28/1981. The Respondent Society, along with the owners, challenged the land acquisition proceedings in High Court in 1989, but the petition was dismissed on the ground of laches and delay, and against this judgment, respondents filed SLP to the Supreme Court. The Apex Court upheld the judgment of the High Court and dismissed the petition with an observation that the dismissal of the SLP would not operate as res judicata if the society approaches the court for the release of the land on the ground that the land owned by similar institutions have been released from acquisition. The respondents filed a second writ petition in the Jodhpur bench of the High Court, praying for the release of the disputed lands on the basis of the observation of the Apex Court. On appeal to the Apex Court, the court held that the Respondent Society had a legitimate expectation of getting a lease of land from the appellant corporation as per the allotment letter issued by the corporation, and the corporation's cancellation of the allotment on the ground of non-payment of dues without giving any notice or hearing to the society was violative of the doctrine of legitimate expectation. In incorporating international law principles into our jurisprudence through PIL, the Supreme Court made use of the doctrine of legitimate expectation. What is this doctrine? The answer to this question is what we'll be dealing with today. The requirement of procedural fairness or natural justice, also called due process, in every exercise of a statutory power when it might have an adverse effect on an individual, unless there is a very clear legislative indication to the contrary, is well settled. The duty to act fairly is a core tenet of administrative law and a predominant feature in the application of the rules of natural justice. It is this protection of fairness that made way for the court's acknowledgement of legitimate expectation. Due process of law has never been a term of fixed and invariable content. Due process of law in each particular case means such an exertion of the powers of government as the settled maxims of law permit and sanction, and under such safeguards for the protection of individual rights as those maxims prescribe for the class of cases to which the one in question belongs. Where doubt exists, law and government are encumbered to come down on the side of individual liberty. The Due Process Clause of the 14th Amendment to the U.S. Constitution, adopted in 1868, states, "Nor shall any state deprive any person of life, liberty, or property without due process of law." The Constitution of India employs the same language in Article 21 but does not include property. The facially clear meaning of the passage is that a state has to use sufficiently fair and just legal procedures whenever it is going to lawfully take away a person's life or freedom in India or possessions in the USA. Thus, before a person can be executed, imprisoned, or fined for a crime, She must get a fair trial based on legitimate evidence with a jury, etc. These are procedural or process rights. A jury, of course, is in the US, not India. The Supreme Court of India has extended due process to procedural guarantees for all fundamental rights, and like the Supreme Court of Canada, in British Columbia Public Service Employees Relations Commission versus BGSEU, Supreme Court of Canada 1999, has questioned the legitimacy of purpose of all rules, policy and statute, making a distinction either facially or by implication. And in Lakshman Das versus State of Bombay, Supreme Court of India, Budhan versus State of Bihar, Supreme Court of India, and Balsamma Paul versus Cochin University, the Supreme Court of India has done the same. This right has three essential ingredients. The first one is sufficient judicial review of administrative decisions. Statutes or decisions of executive policy usually have an impact directly or indirectly on an individual's rights and obligations. Such an impact may lead to discrimination and therefore necessitate judicial review. Judicial review is also a part of several common law legal systems and finds a place in several constitutions. For example, the Constitution of India in Article 32 guarantees remedies in the nature of writs for infringement of fundamental rights guaranteed in the Constitution, and Article 131 protects the original jurisdiction of the court in relation to disputes over legal rights. This guarantee has, by the court's decisions, been enlarged to include judicial review of statutes and executive decisions. In keeping with its guarantees related to the right of access to justice and due process, Article 6 of the European Convention requires that the state provide for the right to appeal an administrative decision before a court that offers the guarantees established by Article 6. The same holds true for the American Convention, the African Charter, and the ICCPR. The case law of the European Court of Human Rights indicates that a court reviewing administrative decisions should have broad jurisdiction, that is, over both the law and the facts. This ensures the individual the opportunity to have a judge rule definitely on the merits of his or her claims with the proper guarantees of independence and impartiality. The European Court of Human Rights in Obermeier versus Austria has held that a limited review is not a sufficient review. Reasonable time. The guarantee of reasonable time is another aspect of due process of law set forth in all international human rights treaties. In the European system, the reasonableness of the duration of the proceedings in criminal and non-criminal cases depends on the particular circumstances of each case. No absolute limit has been established. The factors taken into consideration are the complexity of the case, the conduct of the petitioner, and the conduct of the administrative and judicial authorities with jurisdiction. None of these factors is conclusive. The approach should be to examine each separately and then evaluate the cumulative effect. In the Dumoulin case, Dumoulin versus Germany, the petitioner in his capacity as legal successor had continued a proceeding initiated by his mother to receive a complementary pension for widowhood, since her husband had died in an accident in the workplace. After 11 years and after going through several tribunals, the claim was rejected. The case was brought to the European Commission on Human Rights with a complaint against the German state for violating Article 6. The petitioner argued that his case had not been resolved within a reasonable time. In an overall appeal of the case, the ECTHR held that whatever might have been the value of the benefit being claimed, an interval of such length is abnormal for the circumstances, especially having regard to the particular diligence required in social security cases. Thus, the European Court considered three factors to be relevant in a claim of unreasonable delay: the complexity of the case, the conduct of the petitioner, and the subject matter of the case. The court considered the importance of what is at stake for the complainant. The European Court has also considered that particular diligence is necessary in cases concerning labor situations, civil status, mental health, and where delay may render the claim infructuous. The Supreme Court of India has followed this principle in several PIL cases in mulcting the state with damages for the prolonged confinement of an under trial prisoner without provision for legal aid to allow him to file an application for bail in Rudal Sa's case. On the same principle, as well as the concept of denial of natural justice, the Supreme Court of India has released prisoners confined without trial for periods longer than the maximum sentence that would have been awarded on conviction in Hussain Ara Khatun. If the procedural law does not provide for speedy trial, prisoners were released. Sher Singh versus State of Punjab. And on bail for personal security, where the procedure for pre-trial bail had not been followed in Hussain Ara Khatun's case. The court has ordered the immediate release of prisoners against whom charges had not been framed after a long period of confinement in Kamla Devi versus State of Punjab. Or the trial had been proceeding with inordinate delay, Matthew versus State of Bihar. Or the prosecution was also quashed in a case involving circumstances of inordinate delay, Bishwanath versus State of Bihar. Equal procedural guarantees. This is the last aspect of the due process, and its equality of arms. Each party should have a reasonable opportunity to present her case in a position of equal advantage to her opponent in both criminal and non-criminal cases. The doctrine encompasses basic procedural rights. Procedural rights are special rights that instead dictate how the state can lawfully go about taking away a person's rights when the law otherwise gives them the power to do so. Due process is encompassed in such concepts as fair play, consistency, the right to a fair and impartial trial on the facts in a case, and other fundamental principles of liberty and justice that lie at the base of all our civil and political institutions. In terms of civil rights and criminal prosecutions, due process would include the following: the right to be presumed innocent until proven guilty, the right to be presented with a search warrant before police or any government official enters your home or office or seizes your property, the right to be presented with a warrant for your arrest unless the police actually saw you commit a crime or have probable cause to believe you have committed a crime based on their personal investigation. This is D.K. Basu. The right to remain silent and speak with an attorney before making any statement to the authorities. The right to legal aid. The Supreme Court of India has made it an obligation on the part of the state to provide legal aid, and a breach of fair trial norms if the right is denied, even if the accused does not know of the right to or ask for legal representation. Khatri versus State of Bihar and M.H. Hoskote versus State of Maharashtra. In terms of ESC rights, it would mean, for example, the right to be heard before you are deprived of an entitlement. The Supreme Court of India made hearing mandatory on the basis of natural justice in a statutory procedure which permitted the eviction of homeless pavement dwellers without prior notice. That's Olga Tellis versus Bombay Municipal Corporation. In administrative law, the Supreme Court of India has made an obligation of the inquiry officer in disciplinary proceedings to observe rules of natural justice in Kumaon Mandal Vikas Nigam Limited versus Girija Shankar Pant and others. The right to be consulted in any policy conferring benefits. The Committee on ESCR has identified in its General Comment 4 certain aspects of the right to adequate housing that must be taken into account for this purpose in any particular context. One aspect which involves consultation is cultural adequacy. The way housing is constructed, the building materials used, and the policies supporting these must appropriately enable the expression of cultural identity and diversity of housing. The right to a transcript of all proceedings, hearings, and trials, though you will have to order and pay for them. The right to appeal any findings of a lower court. The right to subpoena witnesses and any documents or other evidence that may support your position or contradict evidence presented against you. UP Awas Evam Vikas Parishad versus Gyan Devi, dead. The principle of procedural fairness or natural justice, as it came to be increasingly applied to administrative decisions, often focused in its later stages on whether the doctrine of legitimate expectation applied. The answer to this preliminary question often depended on whether the courts could identify a particular reason or circumstance why natural justice ought to apply. In all these cases, the doctrine of legitimate expectation expanded the duty of natural justice to include expectations of rights to the relatively narrow range of rights and interests to which natural justice had traditionally applied. In the UK, the earliest cases involved people who held a license or permit or visa which entitled them to enjoy a particular benefit. As we saw in the previous video, the link to which I have given in the description box, in these cases it was held that the grant of license, permit or visa created an expectation that the grant of the license, permit or visa grantee would enjoy the benefit for its expected duration, and that the benefit would not be ended prematurely unless the person was granted the right to argue against that course. Expectations about the exercise of administrative powers may be the result of the issue of policies or procedures used in the exercise of discretionary powers. Such expectations may create future expectations by public statements or promises or by the adoption of certain regular practices. Such expectations may be disappointed when a government agency has acted in breach of a promise or undertaking made to a particular person or a class of persons. When a government agency has not applied current policy or guidelines in determining a particular case without good reason. The claim may be that the policy has been applied inconsistently or perhaps in a way which reflects improper discrimination. In other cases, an existing policy may be changed and a new one applied to the disadvantage of people who stood to benefit from the earlier policy and who may have even conducted their affairs in reliance upon it. Courts have adopted two approaches to deal with legitimate expectation cases. That expectations about the exercise of administrative powers may only give rise to procedural rights. There can be circumstances in which government agencies should be required to fulfill the legitimate expectations that they have created. In India, legitimate expectations arose in various forms. Example, cases of promotions which are normal course expected, contracts, distribution of largesse by the government, that is discretionary grants of licenses, permits or the like, carry with it a reasonable expectation, though not a legal right, to renewal or non-revocation, and to summarily disappoint that expectation may be seen as unfair without the expected person being heard. It was applied in a range of cases which can be summarized as follows. Cases in which a person had relied upon a policy or norm of general application but was then subjected to a different policy or norm. Cases in which a policy or norm of general application existed and continued but was not applied to the case at hand. When an individual received a promise or representation which was not honored due to subsequent change to a policy or norm of general application. And a fourth category, which was a variation on the third, arose when an individual received a promise or representation which was subsequently dishonored, not because there had been a general change in policy, but rather because the decision maker had changed his mind in that instance. Types of legitimate expectation. The doctrine has both procedural and substantive aspects. The classic and the strongest claim is one based on a clear and unambiguous promise, relied on by somebody to their detriment in circumstances where holding the authority to that promise does not have wide-ranging political or other consequences. The second category is the guidance instruction case, in which it is claimed that terms of published guidance, instruction or policy are so clear and unqualified as to amount to promises of particular treatment. The third category are those cases in which can be said that an established practice or policy gives rise to an expectation of consistent or equal treatment, even if the terms of the policy do not amount to a promise aimed at any person in particular. The routine application of the policy to persons in the same category can give rise to an expectation of similar treatment. Procedural legitimate expectation. This doctrine's procedural aspect refers to the procedure that has been followed by the authorities and it remains consistent for everyone. The person claiming to have legitimate expectation has previously possessed an enforceable right which was taken away as a result of administrative conduct. Wherever the claimant has a legitimate and reasonable expectation of having procedural protection of fair hearing, such as providing a fair hearing or being consulted before taking a decision or a change in policy affecting them adversely, the court provides procedural protection to the claimant. In UP Awas Evam Vikas Parishad versus Gyan Devi dead by LRs, the board constituted under the UP Awas Evam Vikas Parishad Adhiniyam 1965 framed a scheme known as the Trans Yamuna Housing and Accommodation Scheme, and notifications were issued as per law. The Special Land Acquisition Officer made an award on April 15, 1978, where amount of compensation was fixed by adopting a belting system. The appellants filed first appeals in the High Court against the award of the tribunal, and after they were dismissed, appealed to the Supreme Court. The board was not impleaded as a party in the reference before the tribunal or in appeals before the High Court. This was the question before the bench. The Supreme Court stated right to notice in proceedings in a court of law or quasi-judicial proceedings are different than the right of appeal. The former may arise either under the statutory provision or the principle of natural justice may require it, or it may be necessary on principle of legitimate expectation. And in situations where even though a person has no enforceable right, yet he is affected or likely to be affected by the order passed by a public authority, the courts have evolved the principle of legitimate expectation. A 5-judge bench of the Apex Court in 4-1 declared that notice to a local authority or a company at whose instance the government acquires land is imperative as a right conferred under Section 52 of the LA Land Acquisition Act carries with it the right to be given adequate notice by the collector as well as the reference court. As per the various cases gone through previously, it can be seen that Indian courts are liberal in the usage of procedural legitimate expectation. This is a natural consequence of the fact that the principles of natural justice have to be upheld in civil orders. The Supreme Court has emphasized that adherence to natural justice is crucial. So, procedural legitimate expectation becomes a tool to ensure the straightforward application of natural justice in civil administration. Further, providing a chance for representation or hearing to the concern before decision making is also legally more plausible. Even in a case where the decision is left entirely to the discretion of the deciding authority without any such legal bounds, and if the decision taken fairly and objectively, the court will not interfere on the ground that of procedural fairness in favor of a person whose interest, based on legitimate expectation, might be affected.